The government's basically creating thresholds that they know are borderline impossible. Another thing that they're trying to do is they're moving the goalposts on the definition of common use. It not only has to be in common use, but it also has to be in common use for self-defense. This is another one of their arguments to ban AR-15s is, well, look, AR-15s are not commonly used for self-defense, even though there is a study that's out there that found that the majority of folks who purchase an AR-15 have identified that they use it for home defense inside the home. And they say, oh, that study's flawed. We can't accept that.
Tom, the gun community has some big Second Amendment wins recently, but it looks like the anti-gunners are sort of, pulling things back together for a counteroffensive. Are you seeing a typical type of action that anti-gunners are bringing together to array their forces against the forces of goodness, that being us and those folks who want to take our guns away?
Yeah, so we are seeing kind of a common legal playbook emerge, I would say, across both the different state as well as federal jurisdictions about pretty common claims that the anti-self-defense advocates, i.e. the gun grabbers, right? Because if you're taking away my ability to defend myself by robbing me of my tools, that makes you anti-self-defense, right? What kind of strategies and what kind of shenanigans are we just seeing come up time and time and time again? Almost like they're copying and pasting off each other almost. So one of it is they're trying to move the goalposts on what does the Second Amendment protect, okay? So quick rehash course, right? So in June of 22, we had the Brune decision come out from the United States Supreme Court. And basically what the Brune decision says lots of different things. But for our purposes here, the super short version is that if something is protected by the Second Amendment, then you have to show that the regulation or the law fits within the nation's historical tradition of firearm regulation. Okay. So they're doing a couple things. One is they're saying, well, it's not protected by the Second Amendment. Okay. Broadly speaking, that's part of the playbook. So for instance, when some folks sued for the denial under the Gun Control Act of 1968 that was prohibiting adults under the age of 21, so people who are 18, 19, or 20, from purchasing a handgun from an FFL, the argument from the anti-Second Amendment crowd is saying, well, look, they're not part of the people, from the phrase, the right of the people to keep and bear arms shall not be infringed. They're not part of the people. Or likewise, they're saying that, well, look, this isn't an arm. An AR-15 isn't an arm. An AK-47 is not an arm. A so-called large capacity, i.e. normal capacity magazine, that's not an arm. Magazines, those are accoutrements, is their word, not mine. That's what they're arguing those are. And therefore, because the Founding Fathers did not conceptualize those, their words, their claim, did not conceptualize those as part of a musket, right? Your little bag of what you would hold, the musket balls in. Therefore, hey, the magazines are not protected by the Second Amendment. So they're moving the goalposts and all those sorts of things. They're basically trying to shift the burden away from the government and onto the citizens as saying, look, you have to prove how this fits within the Second Amendment to gain the protections of the Second Amendment.
So, I mean, taking this to an extreme position, the Second Amendment says that you have the right to keep and bear arms. It doesn't say anything about ammo, so you can have all the guns you want, but we're just going to take away your ammo. I mean, they couldn't make arguments like that if they're talking about magazines as pieces of guns that aren't protected. And you said something that caught my attention right at the beginning, the traditional history of firearms regulation in the U.S. or something of that nature. When do they think that starts? Because traditionally, 1791 to, Gun Control Act of 1934 or the NFA, National Firearms Act, 1934, there wasn't much regulation on a national level. Individually, some cities try to do things and stuff like that. So I think this gets to be pretty clouded.
So you asked about 2 hours worth of questions there.
Yeah.
Which are great questions. That's not your fault because you're putting your finger on the pulse of the issues here, okay? What era are we supposed to be focused on? Yeah. Generally speaking, the pro-Second Amendment folks are looking at what we would call the early Republic era. So the Second Amendment was adopted in 1791. So you're kind of looking at the era that the Founding Fathers were still kicking around. Generally, that that goes through the 1820s, 1830s in popular conceptualization. By the time you get to the 1850s, now we start to see some state-level gun control creep in, largely actually in Western states, but also in certain areas in the South. We actually have gun control going back to the colonies, but a lot of that was all geared at basically ensuring that African Americans, slaves, Catholics, and generally just people that we don't like, just don't have access to firearms and or they don't have the ability to carry them. Some of the very first concealed carry laws were aimed at making sure that the folks that we, being the government, we don't want freed blacks having access to firearms. We don't want them being able to carry firearms. So this is the very, very sordid history of gun control in the colonies in the United States.
Yeah, the absolute racist roots of gun control was to control the newly freed slaves. And you're saying even further back before that.
Oh, it goes well back before that.
I'm pausing the video quickly to remind you that we have a secret giveaway going on that ends really soon, and it's free to enter. Just click the link in the description below to reveal what you could win. Now, back to the video.
We can get into England and that whole area and so forth as well, but keeping this to an under 2-hour video because I was told that's what you guys want.
Yeah, so, less than 2 hours is typically optimal.
Optimal. Okay. Yeah. So that certainly would be an argument as to let's keep it over here. A lot of the gun control really started to ramp up across the state level, even though we do see a sprinklings in the colony and early republic era and so forth. We really start to see it ramp up, particularly in the 1850s, 60s, 70s, and beyond, dealing with basically trying to deprive the right to the free slaves. Now, keep in mind, we didn't have the 14th Amendment yet. The 14th Amendment was the amendment that basically extended the Bill of Rights to protect against the state government. In English, please, Tom. What this means is that when you had the First Amendment right? First Amendment right to free speech, religion, so forth. That was only a check against federal power. So that meant that Washington, D.C. couldn't interfere with you. But your state and local level governments, theoretically, there were no protections against them, right? So we saw all this gun control come out at those levels. Well, the 14th Amendment came along just immediately after the Civil War, but then almost as immediately, there was a U.S. Supreme Court case that said that 14th Amendment does not apply to the First and Second Amendment. That would not be undone for the First Amendment until the 1920s and would not be undone for the Second Amendment until 2010.
Wow.
Right. So then we had the National Firearms Act in 1934, right? And then we had the Gun Control Act in 1968 and Firearm Owners Protection Act, Crime Control Act, all these other things started happening then.
Yeah. The first question was about the ammo and the magazines because the Second Amendment doesn't specifically, and I know how you attorneys can be, doesn't specifically say we can have ammo and magazines. It says we can keep and bear arms.
You're right.
But if they can restrict our ammunition and our ammunition devices, things of that nature, can they not then effectively make our guns useless?
Well, so this has been dealt with both somewhat in a head-on manner as well as tangentially. So there's been some lawsuits that have come out of Chicago, actually, where Chicago is basically trying to get rid of gun stores, get rid of gun ranges. And in essence, what the court said is, look, if you deprive people of the ability to exercise their right, you're basically taking away the right. So between that, as well as some wording in other cases, the ability to purchase ammunition, the ability to purchase firearms, the ability to have reasonable access to use your firearms at ranges and so forth, that's all now baked into the pie. Now, is that in a really good way where we have an extremely reasonable level of access, or is a 6-hour drive going to be considered a reasonable level of access, right?
Right.
Somewhere between those two, right?
Okay.
We'll have to see where all that goes. But as far as the accoutrements go, this is the attack on so-called large capacity magazines, i.e. normal capacity magazines. This is the attack as well, not the accoutrements, but the fact that it's an unusual and dangerous weapon when we're talking about AR-15s, AK-47s, Steyr AUGs, all that kind of stuff, the so-called assault weapons.
Yes, those are unusual when in fact AR-15 is the most popular rifle sold in the country. It doesn't make it unusual.
Yeah, by a wide margin as well. Depending on who you believe, there's well over 20 million that have been sold and are currently in circulation out there.
Yeah, and that just set something churning in my head. Back in 93, the first assault weapons ban, I'd heard that there was like less than 1 million AR-15s in private ownership in the United States. And the assault weapons ban just really drove interest in making sure I could get one before I couldn't get one anymore. And that market has entirely taken off.
Yeah, I'd really say in the last 15 years. I mean, if you remember back then, as I'm sure you do, I mean, these days you can't swing a dead cat without hitting some sort of new AR-15 manufacturer that's sprouted up. And back then, you just kind of had the big three, right? Armalite, Bushmaster, Colt. Yeah. There were a couple others that I won't name, but I mean, those guys, ABC, they kind of ran the show, right?
And I just want to make it clear that in no way will we be swinging a dead cat. That was just a phrase of speach. That we don't harm animals here.
We do not harm animals here. This is true.
I just wanted to make that
I used to own
clear.
a cat.
Yeah.
Right.
So.
But right. So those are some of the legal tactics that we're seeing, is basically saying, look, this isn't an arm. These are not the people. This is not in common use. I saw in an Illinois brief, if memory serves, at the state level, that the Illinois Department of Justice was arguing, well, look, founding fathers, when they're talking about common use, they were talking about the fact that between 50 to 60% of households at the time had some sort of musket. So the implication was that, well, if 50 to 60% of households don't have this particular type of weapon, then therefore it's not in common use, which means that there's no weapon that's in common use, because there are so many weapons out there. I mean, there's thousands of different types of weapons if you break everything down into models, right? So by that point, no one thing is going to have 60%. I mean, 60% of households don't even own a gun. Yeah. Or if not, we're close.
And so, no way are they going to own one specific type of gun. So
right. So the government's basically creating thresholds that they know are borderline impossible. Another thing that they're trying to do is they're moving the goalposts on the definition of common use. It not only has to be in common use, but it also has to be in common use for self-defense. This is another one of their arguments to ban AR-15s is, well, look, AR-15s are not commonly used for self-defense, even though there is a study that's out there that found that the majority of folks who purchase an AR-15 have identified that they use it for home defense inside the home. And they say, oh, that study's flawed. We can't accept that. But they're trying to create, much like if you go back before DC versus Heller and before Bruin particularly, remember what the gun grabber arguments were if you go back 15, 20 years?
They were all over the place.
They were all over the place. But the one I'm thinking of is they would say, oh, there's no sporting use for that. There's no sporting use. As if the Second Amendment existed to allow us to hunt ducks and deer, right? Now they've flipped it around. There's no defense use. Yeah. But I just kind of sprinkled all the pieces out there. Let's put them together. Okay. So there's a common use test, which means that it has to be an absurd number of them, right? We now have a defense in common use test, right? We also have an accoutrements and accessories, and then we also have a who are the people, but we'll just set that to the side for a moment. What this all basically boils down to is the fact that, look, semi-automatics, those are basically, in essence, not protected by the Second Amendment, because what good is a semi-automatic if they can limit it to 2 rounds or some arbitrarily low amount of rounds, right? So we're basically, if you really follow all the anti-Second Amendment arguments, we're going to be left with J-frame revolvers, maybe Colt detective models, D-frames and stuff like that. Like that's basically, if you follow in absurdium, because I'm a lawyer, I have to use Latin, right? If you follow the arguments to their extreme, to where they are going, to where they are pointed, that's where they are pointed, is basically all semi-automatics are going to be rendered essentially functionless. We're going to be stuck with revolvers, and Lord even knows whether or not they're going to be allowed to have 5 or 6 shots in them, of course. Right. And that's would seem to, I'm not going to call that the end game, because the end game is ban everything.
Right. The end game is no guns.
The end game is no guns.
We don't want private ownership of guns in America.
So that would appear to be the end game, but this would appear to be the stepping stone to get there.
Absolutely. The long and short of it is the fight is not over. Even with all of the great 2A wins we've had in the courts, the fight to protect our freedoms is not over, is it?
We've won a tremendous amount of battles, and those battles are going to be extraordinarily important. However, without winning elections, particularly presidential elections, who make up and get to choose who wins the U.S. Supreme Court, this can all be undone with enough time.
Yes.
So that's going to be the key, is that with enough time, these can all be undone. So if you value the heritage, if you value the tradition, if you value the meaning and purpose of the Second Amendment, to bring freedom and life to people, to make sure that people don't have to live in fear and tyranny of who could be coming through their front door, then you need to become politically active enough and savvy enough to understand and that our rights are under constant. Doesn't matter if it's First Amendment, Second Amendment, Fourth Amendment, you name it. Our rights are under constant attack.
Very well said. Thanks again, Tom. I love your insight.
Thanks, Kevin.
And because you made it all the way to the end of the video, we have a special shout out going on. We will randomly select one person who gives us the right answer as to how many rounds of ammo are in this cup. And we're going to randomly choose one winner, one person who gets it right. I'm going to put their name on the screen. You get to be famous like me. Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.